I'm very happy to welcome on stage first Albine Vincent, who is head of the DPO department at the French Data Protection Authority since 2012, and you've been with CNIL since 2007, I believe. So warmly welcome. And we also have Eija Warma, who you've seen in the very first session, and she has already introduced herself, but you're very welcome. And last but not least, we have Mr. Viljar Peep, who was head of the Estonian Data Protection Authority for 10 years, 2008 to 2018, and is since just recently Vice Chancellor of the Estonian Ministry of Justice. So very welcome. Thank you. I suggest we sit down. So, following all the heavy lifting that I'm sure all of you in this room have been part of, and I recall when reading through the leaflet, there are some 250 companies and authorities and local councils here and advisors. And we all had our fair share of the heavy lifting, but on the other side of the GDPR, I think all of us could see a fantastic opportunity of finally a harmonized level playfield for all the companies throughout Europe. And we're going to start off turning to you, Albine. Do you perceive that the GDPR has in fact already accomplished the harmonization that was first intended compared to the previous directive?
First of all, is my microphone? It's okay. First of all, thank you for the invitation. I'm very pleased to be part of this panel. As you previously said, I am at the CNIL now for more than 10 years, 11 years. And during May, on 25th of May, with my department, it was a very big day, the 25th of May. And for us, data protection was starting this day because it was serious and it was real. Well, of course, everyone in this room maybe think the same because of the sanction, but we think it was very important, very serious, because of all the mechanism put inside the GDPR, and especially the mechanism to make all the decision consistent at European level. Sorry. So it was a big day, but it's not easy, of course, and of course it has changed if we compare with the directive. To answer your question, this new mechanism were not existed before, so we have to make them work. We have to make them. We have to enrich them with tools that they are developed at European level, but also at national level. Maybe we can discuss later of that. So yes, it's new, and it's a new regulation. But maybe it's interesting to know how the European Data Protection Board works. There is you can find online and the report of the last 4 years and how it has been possible to create so many. Maybe it's not enough for companies and different stakeholders, but we produce many opinions, many guidelines. We had 3 Fab Labs, public consultation, and we organized more than 165 meetings between all the data protection authority. maybe it's a big figure for to say only 12 guidelines for this number of meetings, but it was regarding many topics, not only published on the website of the Article 29 Working Party and on the website of the European Data Protection Board.
Well, thank you very much. And speaking of which, we now have someone live who's been part of the Working Party 29 for 10 years. So, Viljar, what is your view? In what way can we now see actual harmonization and real things that are facilitating for the companies to apply a harmonized principle throughout their companies in the EU?
Well, first of all, thank you for inviting. Det nällad vara här Münchenbryggeriet igen. But talking very frankly about harmonization of data protection in Europe, let me say very frankly that we don't see it in our lifetime for several reasons. First, if to take the data protection legal framework itself, then yes, it's regulation. It's regulation, but it's very directive-like regulation. Not just mentioning Article 23, which allows make derogations and exemptions by national lawmakers. It's also allowed to make exemptions or additional rules related to TPO appointment, related to impact assessment obligation. There are references to national law in context of employment law, media law, etc. If to take legal grounds for data processing, then actually legal obligation as one of them. It's decided by the national law. If to take public tasks or public power, it's again up to the national lawmakers. If to take contract law or procedural law, again, it's a national law. So, if to take the legal framework, then it's not very promising. Secondly, you know, data protection law is not self-implementing. It's not self-implementing. It means that very much depends on the traditions and also how people in different parts perceive privacy and cyber matter. It's very useful to look at the Eurobarometer surveys conducted by the European Commission. The most recent one was again comparing how people in different parts of Europe trust automated data processing in by different processors, by public authorities, by hospitals, by financial institutions, e-shops, etc. And if you think that the most lowest level of trust and confidence was in Southern Europe, then you're wrong. The lowest was actually in English-speaking countries. And then the highest level of trust and confidence, well, Sweden, Finland, Estonia. So you can't just change the brains how we behave and which is actually considered to be normal in different parts of, in different regions of Europe. And if to take our Honorable Data Protection Board, I can now say some words from distance. You are a bit, how to put it politely, swamping. Because the main work of the board is still like of the previous working, but it's soft lawmaking, issuance of adoption of guidelines. And the number of guidelines is big, and you can imagine guidelines have to be adopted by 27 plus EDPS commissioners or data protection authorities. If I remember correctly, it's your topic, DPOs. Then the common guidelines on DPOs, which was number of the very last version which was adopted? 43rd, I guess. So you can imagine the workload of drafting texts and rewording and rewording of text. It's huge. So definitely, if you are already looking some kind of practical actions to harmonize data protection practice in Europe, then we are very far from it.
Okay, thank you. I should turn to you, Eija, having...
Maybe I can answer.
in a little while, I would like to ask you, Eija, coming from the council side, advising a lot of corporations throughout Europe, and we see CNIL and ICO producing quite a lot of guidelines. Well, do you see the same if you look throughout Europe? Isn't it even so that some DPAs may be reluctant to provide guidelines while awaiting guidance from EU, meaning the European Court of Justice or the European Data Protection Board? Or would you say that it's crystal clear in all the markets to the clients that you advise?
Well, first of all, I can agree what was said earlier here about the harmonization and actually lack of that. Maybe before the GDPR, the hopes from business side and the industry side was that finally we're going to get one set of rules and we get rid of all the national exemptions on that. And as we heard, we really are not there. And maybe there were some talks at some point that lawyers in a small country is going to lose our job because then the companies would follow and go to the big business centers in Europe. But as we all know, that's not really the case. There are a lot of national exemptions as the employment sector being one of them, and all the national laws that comes to the picture. In Finland, we don't have that yet, but hopefully in the coming weeks, we are one of the last countries not having the national law in place. So, I mean, there are a lot of variations on a practical level. And at least in the jurisdiction where I come from, Finland, we haven't got basically at all local guidance or regulation, but it's more like European Data Protection Board's guidance translated into the local language. And I guess the dialogue with that is that since the national authorities are bound by the European Board's decisions and guidelines, they don't see that they can take sort of their own lead in any subject matter, and that's why they are linking their local work to European Data Protection Board's work and kind of waiting what's coming out there. And maybe one additional non-legal issue, so to say, I would like to raise at this point is a language question. A lot of authorities, at least to my experience, is that they want the communication to take place in the local language. So that brings also the cultural issues, a way how you communicate with local people and authorities. So I mean, there is a strong local angle on any case or any issue that you are really looking into under the GDPR as well.
Well, thank you very much for that. And you touched a little upon the question of, if I may interpret, forum shopping, that given that the local DPAs are working under different conditions, with different budgets, with different cultural heritage in terms of how much data have you traditionally processed. And here in the Nordics, we're quite used to having quite a lot of personal data being fully in the open, while in other countries it's not the case. So, and this is an open question to all three of you. Would you see a risk of forum shopping now while sort of awaiting the European Court of Justice and further regulation from the European Data Inspection Board? Please feel free.
It depends on what do you put on Forumshopping. If we are talking about sanction, the Forumshopping to avoid sanction, it will be difficult for cross-border processings to avoid sanction, because we are bound all together, all the DPAs together at the European with the European board, which control and check the consistency of the decision. And this is a major part of the harmonization. Of course, there is some lack, which are the national exemptions, but this is not only the exemption that GDPR talks about. We have national exemption regarding, we call that Police and Justice Directive, which is a big exemption. Even the European regulator tried to harmonize, but not with a regulation, but with a directive, which is legally different. We know we have a lot to do, but if we consider if there is a risk of Forumshopping regarding the sanction point of view, I think that will be very difficult to make this kind of decision. But on a national point of view, if you are implementing a national processing regarding the means of the data protection authority, the capacity to investigate on site, the maturity of the team, I don't know, the growth and the numbers of employees of this national authority, it can be, but it's not Forumshopping. This is when we are talking about Forumshopping, it's between countries, the EU. But if you want to develop, or maybe to be more in a context without any inspection or control, maybe some country will be offer a good place to develop some, I don't know, technology for that, but I don't know.
So Eija, if I turn to you, would you have any examples from your counseling to countries who are still 6 months with GDPR, perhaps reluctant to roll out their uniform EU policies and scalable products in all European countries because they fear there is a risk of sort of a non-harmonized application?
Well,
that's a very leading question.
Yes. There are those ones who really carefully think like what's the moment and what's the angle and what's the region on where to launch things and how it's received by the public. But I would like to say maybe a few points on this Forumshopping. I mean, obviously the GDPR offers quite limited possibilities on Forumshopping. There are rules on the links of the incident or people to certain jurisdictions, and then depending on those, the authority or lead authority is chosen. But I mean, I had a case in this during the GDPR months where it was a data breach incident that involved heavily two markets, Finland and Sweden, and we were actually thinking quite carefully on which country to notify. And maybe Finland and Sweden are similar to one another, but if we look at the trend in Europe, I mean, we've heard news from the UK and ICO issuing fines quite a lot in the past weeks. We know that the Data Protection Authority in Ireland has heavily implemented on personnel and they've got a lot of funding from the government. So I mean, obviously, once you need to pre-evaluate something, you need to contact the DPA or you need to somehow communicate with the DPAs. I think the companies are evaluating quite carefully where to start the discussion and what would be a good authority to move on with the case. It's not really like you mentioned a forum shopping, but with the limited possibilities, deciding what's the good place to raise the issue.
So, Viljar, coming from the inside, so to speak, for the past 10 years with the Working Party 29, do you see any trends on how the local data protection authorities are moving forward in the harmonization? Or is it a fully unified
Again, not
discussion?
in our lifetime, but 5 years ago we had Estonian British project within the Article 29 Working Party. It was about the mapping of powers and real activities and statistics of member authorities. Then our powers were different, but one thing is if you have powers, another thing is how to use it. If to take efficiency of data protection authorities, then whatever country we take, Sweden, France, Finland, who are the smallest regulators by the size?
The smallest.
It's the smallest. If to compare data protection authorities and tax authorities, competition authorities, financial sector supervisor authorities, healthcare authorities, etc., who are the smallest by the size? Definitely we. I mean data protection authorities. So if we have so small resources, then it's a question, are we dealing with the forest or with the trees? Are we dealing with single infringements and complaints or trying to have some kind of bigger influence or impact? And now, okay, we are supposed to have the same prerogatives, the same powers across European Union. Dear colleagues, dear audience, if to take a central article related to the cross-border proceedings of data protection authorities, it's Article 60. It's a page-long article. Then my humble question is, if you read this article, is it about complaints-based proceedings or is it about ex officio on the own initiative proceedings? What do you think? If you have read the long page, then at the end you can find which authority has power to make decision. It depends. Was the complaint accepted or rejected? Complaint, which means that if to take the present regulatory toolbox in possession of every data protection authorities, then by the letter of the regulation, it's about dealing with trees, dealing with single infringements and complaints. Well, I remember our comparative mapping, then the legal administrative practice of member authorities was really very different. Even if I remember comparison of some Nordic countries, it wasn't Sweden or Finland, then the proportion of proactive and reactive workload was really, if I remember correctly, 80% and 20%. It's very different. So this is about efficiency and how, about whom you should afraid of and well, whom not.
Okay, thank you.
If I may add something about...
of course you may.
Thank you. If I may add about thresholds and barriers, then if Eija is looking for differences in your legal practice, then it's a question that a case can be a data protection case in some countries, and in some other countries it's, for instance, a criminal case or a case for other regulators. For a very simple reason, whatever we take, identity theft, it could be criminalized in some member states, which means it's not data protection anymore, it's a criminal case. And the same about distinctions between, for instance, labor law and labor inspectorate or whatever authority there is, or data protection, or the same about banking data or healthcare data. So it could be a data protection case, it could be a case for another regulator. And there is also a very important, essential parameter. It's about intervention threshold. Because in some countries it's so that authorities, especially data protection authorities, just have to react if there is a complaint. And in some countries it's a matter of choice. Is there public interest to intervene or not? So yes, this is perhaps the most essential factor if to choose the different approaches of different member states.
Thank you. While all the local DPAs are no doubt striving for a harmonized supervision, do you believe in practical steps could be taken, such as making it mandatory for the local authorities to publish all the guidelines in English, in sort of a common? You touched upon that, Eija. I mean, it would seem like a good thing to do to increase the harmonization level. What's your thought on that? Given the workload you described, would that just be one thing too many?
Well, actually, it's easier to communicate when you are the ICO because your natural language is in English. It depends on the budget. You have to translate all the documents and the willing. So it's not neutral. It's not a neutral question. But for example, in France, we decided to translate some our national guidance. Because even you are a French company, you can be a French company depending on an international group. So it will be interesting to give this all this documentation to the board, which can be outside the EU. And for example, all the documents on DPOs, on the guide on processors, and soon the new certification of DPOs qualification schemes will be in English in order to spread and to help the comprehension of the subject. But it's just there is no national interpretation because it's just a manner of proposing tools, but there is no, in my point of view, this national guidance are very linked to the European guidances. So we can propose at a European level to make with this document as a basis of work, potential discussion on it, and to and be able to create this this new guidance at EU level based on this. So it's very useful. Usually, it's useful, and it's not a national exemption. This is what I want to say by this kind of guidance.
Yes, Viljar, please.
Well, about availability of soft law made by the national authorities, I can say in French, comme ci, comme ça.
It's from the Normandy. So
Merci.
you want to be precise.
Yes, we decided to adopt just one single codified guidance document, a general guidance for controllers and processors. If to take all the data protection legal framework, I mean the hard law, the regulation, directive, national law, and the European guidelines, and it's about 500 pages. And I'm proud to say that our guidelines is just 10 times shorter, 50 pages. Unfortunately, it's only in Estonian, but I promise I will encourage my former colleagues to translate it into English. Second is special guidelines, I mean sector-specific guidelines. We decided that we are not adopting guidelines for sectors, but this is a matter of sectors themselves to adopt self-regulation, voluntary standards, different certification schemas provided by the GDPR, etc., and we support them. And of course, we can't, well, control this kind of procedure, and it depends on the business associations and different professional organizations themselves to translate it into English or not. Yes, it's a huge number of documents.
So are you then like cooperating with the industries in the codes of conduct?
Yes, because they know their practical problems better than the Data Protection Authority. Data Protection Authority can just provide, well, general support. Mm-hmm. That's it.
Well, thank you very much. I believe we have a few minutes for questions, and I don't know if we have a microphone. We do have. So anyone who would like to ask anyone here on stage something, please feel free. There are very few hands in the air.
Can I ask a question? Maybe
well, you can absolutely do that.
Thank you. I would like to ask from my co-panelists here, you're representing two different authorities in different countries, and we have a room full of people working in data protection and privacy, and I'm also interested to hear your message to us. What we could do as a practitioners and organization representatives that could make your life as a regulator a bit easier. What will be maybe the messages for communication or issues to brought up to your desk? So any thoughts and tips on us?
Well, I heard two messages to the Conference of Estonian Data Protection Officers. One was about asking questions from the Data Protection Authority. The message was that if not you are asking, but your colleagues separately, without you directly turning to the authority, then it means that you are data protection officer just on paper. You are not taken as a functionary in your organization, and then it means that we don't trust you. And second, if to take rules on DPOs under the GDPR, then second message was very clear. We don't care about how independent you are in your organization. You are not ombudsman. You are not some kind of internal data protection authority within your organization. You are point of contact, and you are consultant, and you are interpreter. I mean, those who know data protection and those who not. And only thing what matters is what is your expertise, what is your competence, what is your knowledge and skills. That is the only thing that matters.
With those final guiding words, I may thank all of you very much for participating here today and sharing your valuable insights. So again, many thanks for joining us.
Thank you.
We're now going to have like a 3-minute break, so you can check on your emails and then be back in your seat in 3 minutes.